All right, the next case on the calendar is Homestead Air Force Base Developers, Inc. versus Miami-Dade County. All right, if you just wait one moment till we get set up, counsel.
Yes, sir.
All right, if we can get it quiet in the courtroom, please, so we can hear argument of counsel. Ready to proceed?
I am, sir. Good morning, Lawrence Gordich and Melissa Logna on behalf of the appellant. It's a pleasure to be here today. As the court is no doubt aware, both the movement's burden and the de novo standard of review would compel reversal in a summary judgment case such as this unless every possible inference is drawn in favor of Habde and against the county. Every piece of evidence is viewed in a light most favorable in favor of Habde and against the county. And after which, your honors are left with, quote unquote, not the slightest doubt that there is any material fact that is at issue that would preclude summary judgment as a matter of law. It's our respectful position that the uncontroverted affidavit of Mr. Herrera and the record below preclude that. We believe that the good faith, diligent efforts of the county, which has made a specific contractual provision of the section that the trial court relied upon in entering the summary judgment in favor of the county, presents a factual issue that must be addressed by a jury.
All right, well, let's just tick off, if we can, by bullet point, the facts that you say need to be flushed out. Factual issues. Go ahead.
Yes, sir. I would say there's quite a few, but I'll give you the top 8. And the top 8, if it was David Letterman, we'd make it the top 10. But the top 8 that we really think jump right out at you, or we hope, are that when you look at subsection Article 2, Paragraph 2 of the section that the trial court relied upon, in the last portion of it, which is which is addressed in the affidavit of Mr. Herrera, and
this is under the conditions precedent?
Yes, sir.
Okay, go ahead.
It specifically says there in the most unequivocal language that it is based, and let me just read this one little part here. Neither party shall have any liability or financial responsibility hereunder to the other, and shall have no grounds for suit or recovery against the other, provided that good faith, diligent efforts were reasonably made by county and lessee to meet such conditions preceding.
All right, so good faith, diligent efforts. Is that what you're talking about?
Yes, sir.
Okay, next one.
The next one is whether the conditions precedent in Article 2, Section 2 of the agreement upon which the trial court entered summary judgment were in fact waived, and are they a stop from raising them, because it's important to note, Your Honor, that after this, for 7 years, the relationship was very good, and the county negotiated with the Air Force, and Habde went to all of those meetings, participated in all those meetings.
How this contract failed completely, did it not? All of the prerequisites, the contractual prerequisites to its existence, did not occur. The contract involved a lease of the entire area. A very large portion of the entire area was no longer within the possibility of being leased. Isn't that true?
Your Honor,
how you could be in good faith to a fairly law. Good faith is a part of every contract, whether
yes,
it's written or not. But you can be in total good faith and not be able to meet the conditions of the contract, or you can be in total bad faith and still be bound under the and still have to. The other side is still not able to sue you if the contract does not exist.
Your Honor, if you'll pardon me for a personal observation, for 28 years I've both dreaded and anticipated the opportunity to say, Judge Schwartz, I respectfully disagree with you. The reason why is because in this particular situation, there is a
How can you disagree with what I just said?
I'm going to tell you right now, sir, and hopefully
You can
explain it.
say your observations, while entirely accurate, and correct, do not apply to this case.
Your Honor, I would like to say that, but I really must honestly say I respectfully disagree, and here's why. Because I believe, and I say this gingerly, that there might be a flaw in the way you're looking at that, because we must remember that over 700 acres were in fact leased to the county, and subsequently over 604 acres were deeded to the county. And although there are sections in there are sections in that agreement that contemplate that the three basic areas might not be conveyed. And it had a contemplation of what happens if the airfield/terminal portion was not conveyed. So, Your Honor, what I'm respectfully submitting to you is that's not a condition subsequent, as they sometimes argue, or a condition precedent, as they sometimes argue. And by the way, Your Honor, even if it were, they have waived that when in 2001, after the Air Force entered its supplemental environmental impact study, which it did in 2000. It started in 1997. And after it entered its SROD, or Supplemental Record of Decision, which it did in 2001, the county commission got together, held a vote, and affirmatively and knowingly decided to join as a co-plaintiff in the lawsuit in front of the District of Columbia. So
Was that successful?
No, it wasn't.
So how can you be stopped from trying to do something that didn't work?
Quite glad you asked. Because what happened, Judge, was...
I hope you answered.
I'm going to do my best. As I said, for 28 years, I both feared and wanted this opportunity. And here it comes today. Well, it's important to note that, and this ties into my colleagues are making an argument to you that there's some sort of estoppel on us, or there's some preclusive effect by the district court, either the trial court or the appellate court, District of Columbia's ruling.
Well, I do want to point out, as they've noted in their brief, page 10, that you have an inconsistent position because you have previously in this litigation said that the county diligently pursued everything that they're supposed to do. If I'm, again, point me if I'm incorrect.
You are incorrect.
Well, that's okay. So they're incorrect because I'm just quoting from their brief. Page 10.
That's even better.
Okay.
They're incorrect, Your Honor, because you said this case, and I hope what you meant is the District of Columbia
yes, the District
case.
of Columbia that involves all this litigation, whether or not you can have an airport out at the Homestead Air Force Base.
Well, let's be very careful with the term airport, because there's a commercial airport and there's other type of aviation purposes. That's not germane to the question you just asked me, but it is going to be important later.
Okay.
So as to
well,
the
you're
question,
running out of time, so we better make the important later. Now.
then I better go quicker. And let me just say this, Your Honor. If, in fact, it were the same parties to the lawsuit, which it was not, because let us not forget that 5 years before the District of Columbia Court entered its ruling, the county unilaterally had these objections, decided to dismiss itself as a co-plaintiff. So they're not a party. Number two, both of the estoppel arguments that they make are hinge upon that it be the same cause of action. It was clearly not the same cause of action. Rather, the cause of action was by nature of mandamus to try to get the Air Force to adhere to the 1994 ROD that it had originally done.
And your position is that their failure to do so, or to get the Air Force to do so, was irrelevant to your suit on this contract?
I didn't catch, was what, Judge?
Was irrelevant. Even though they didn't get the Air Force to do so, even though they tried, and you tried, everybody tried.
Oh, but
even
Judge.
Even though they didn't, that was irrelevant to this lawsuit. You still had the right to sue for the rest of the property.
That's correct. But in addition, that is correct, but in addition to that argument,
Well, I'm glad it's finally happened.
I'm glad, and I'm shaking in my shoes disagreeing with you on things and glad I can finally agree on something, Your Honor. Let me also say, though, that I just lost my train of thought, and let me find where I am. And
All right, well, why don't you save your time for rebuttal? Because
I should.
That might make the most sense. Okay. All right, we'll hear from the other side. And by the way, counsel, your co-counsel, I believe, is also a St. Thomas graduate. Is that correct?
she is, Your Honor.
Right.
And from what I understand, a past student of yours.
Yes, a pick of the litter, actually. All right. That means okay.
With that and a quarter, etc.
Oh, please, they get an internship.
Okay.
All right, okay. Counsel?
Good morning, Your Honors. George Martinez Esteve, together with David Murray and Deborah Herman. I'm here on behalf of Miami-Dade County. And I'd like to note, by starting, Judge Gersten, you asked the question, the same question that Judge Hubbard repeatedly asked counsel below. What are the facts you're trying to get at? And I'd like to start by telling Your Honors that Mr. Gordich focused on the fact that for 7 years we've worked together. And the facts that are not in dispute, he hasn't disputed them, both their initial brief and their reply brief are rife with instances where they repeat that through the issuance of the SROD, the Supplemental Record of Decision, in January 15th of 2001, the county did nothing but work together with them in good faith.
Well, you did work together for quite some time, is that correct?
That's right.
So what happened all of a sudden when the county backs out? Can
Well,
you at least focus in on that point?
Yes, Judge.
And how you, by backing out, conformed with your agreement with opposing counsel's client?
I think that's exactly the issue that this court needs to key in on. On January 15, 2001, the Air Force tells us both, we are no longer going to give you the entire property and we're not going to let you use it for an airport. The Supplemental Record of Decision says this property shall not be used for airport purposes, period. That's a direct quote. Congress a month before had said we don't want this property developed because of environmental concerns for use as an airport either. So at that point, they agreed we did nothing but act in good faith. And what I tell Your Honor is that at that point, these conditions precedent were either triggered or not triggered, depending on how you want to define it. But at that point, 2.1.1 says that a condition precedent is that the lease is executed between the county and the Air Force for the entire premises. It's a defined term. It's defined as the whole base.
But isn't counsel correct that saying that the contract also contemplated and provided for the remedies when that could not take place?
I'm glad you brought that up, Judge Schwartz, because I was going to mention it as well. It does not provide that. He's citing a provision that's 2.1.4. It's FAA approval. And that provision only applied if the airport conveyed the entire property to the county, but because the FAA sometimes has a concern with a private operator managing an airport.
The language that I'm looking at is if notwithstanding the foregoing, the FAA requires that the county not lease the airfield in the terminal to the lessee, the parties agree to modify the lease. Would that suggest then that there's something else just besides the airfield?
Yes, Judge. To make these consistent, the way that it was worked, this was supposed to happen in stages. So the first condition precedent is if the county gets the entire property for airport purposes, the entire property, we agree to lease it to you. A subsequent condition precedent says, however, if the FAA expresses concerns, because the FAA sometimes does not want a private operator to manage a public airstrip and therefore keep out possibly a competitor. So if the FAA issues a comment and says, we don't want HAVD to manage the actual airstrips, the actual airfield, then we agree jointly, if the county has received the entire property, we agree to carve that out. But that would allow the rest of the lease's intent to be pursued. For example, that we got the entire property, 1, or 2.1.6, which is that we received a final Air Force decision to declare the base surplus property and provide for its conveyance for public airport purposes.
There's also a provision in their council that whereas upon receipt and acceptance by the county of a legal interest in the designated premises, that this lease will have full force and effect and be binding upon the party as a sublease agreement subject to the long-term lease and upon subsequent receipt and acceptance by the county of fee simple title to the base or portions thereof.
That's right, Judge. And
does that not suggest that the parties contemplated that there would potentially be might be something less than 1,600 and some odd .8 acres conveyed.
It's a good question, Your Honor, and Happy has focused
Once in a
on.
while I get lucky, and
I have a good answer, I think, Judge.
All right.
This is what I'll tell you. This clause, I think, is consistent with the county's reading of the rest of the contract. As Your Honor read, it says, upon receipt and acceptance by the county of a legal interest in the designated premises of HARB. HARB and designated premises, and long-term lease, by the way, is also a defined term. That's defined as the county's application to the Air Force to receive the entire Air Force Base. So the first part of that requires us to receive a legal interest in the designated premises of HARB pursuant to the long-term lease. So if that condition isn't met, you don't get to go on. And what I'm telling you, Your Honor,
what does HARB stand for?
HARB stands for Homestead Air Base. So,
The Air Force Base.
and the designated premises is also a defined term, Judge, as is long-term lease. So, Your Honor, what I'm trying to explain to you is that what the parties were contemplated in these whereases and in subsequent provisions is that the Air Force might express, or the FAA might express an opinion as to whether we were allowed.
This says nothing about the FAA. This just talks about the premises and portions thereof
I was-
conveyed.
You're right, Your Honor. I was just
This
tying.
particular provision, I understand you have a disagreement in interpretation of 2.1.4, but this suggests that there might be some agreement with respect to a portion. But let me ask you this.
Yes, Judge.
Am I not correct that prior to dismissing itself as a plaintiff from the litigation in the United States District Court of the District of Columbia, that the county had already decided and announced that it was going to pursue the economic development conveyance?
Yes, Your Honor. I think that's a good point for us. But at the same
Well,
board vote.
Let's probe that.
Okay.
That was, my understanding is that your position is that from the time of the injunction hearing forward, that the party's contention is that that's the disputed time, but you had an obligation, you agreed you had an obligation to act in good faith with respect to the people with whom you signed the agreement, correct?
Yes, Judge.
Prior to, and all up until at least the time that you withdrew from the federal lawsuit, it's your position that you did, correct?
No, my position is we've acted in good faith all along.
Well, at least up through the time of the injunction, when you withdraw from the federal suit.
Yes, Judge.
Up through that point in time, and up through that point in time, in the federal suit, you joined the plaintiff, the appellate here, arguing that the Air Force should convey all 1,600 acres and there ought to be an air base, correct?
Yes, Judge.
But at the same time, in the back room, you were also, county was also, as you just said, pursuing something different, an economic ECD, the Economic
Development Conveyance,
EDC. And it seems to me that if we're here on summary judgment, or appeal from a summary judgment, and you must demonstrate that you negated everything, that might be the beginning of some evidence that Dade County, for all sorts of reasons, political and whatever else might have been there, decided that it would do one thing publicly and another thing less publicly.
I'm glad you brought it up, Judge, because they don't cite to it in the record, and I will file a motion to supplementary.
Okay.
On March 8th, 2001, the board took a vote to join in the lawsuit. What HABD doesn't say in their brief is that the same vote was a dual vote. The Air Force gave us 90 days, gave the county 90 days to apply for the remaining property, and the board, at the same vote, March 8th, 2001, where they voted to join the lawsuit, also said, and HABD was in attendance at that hearing, said, we are also going to simultaneously apply so that we don't lose out on this potential public resources of 700 acres. We are joining the lawsuit to see if we can prevail and pursue our intent of providing an airport. However, we are also going to apply for the economic development
that,
conveyance.
of course, creates a dispute, a dispute of fact as to which was really true. What was the county's true interest? Was the county's true interest the airport, or was the
But
county's
the
true
expression
interest?
of the interest if it's contrary, is meaningless. The question is what was done. Well, whether there was anything inconsistent with or contrary to the interests of the plaintiff in this case.
Here's why.
I mean, thoughts alone do not give rise to a cause of action. Even bad thoughts.
Well, I agree, Your Honor, but here's why they don't matter. The thoughts or the actions.
Because the thoughts were not bad. It was a fallback position. If we lost,
That's right.
we hope to get what you want.
Beyond that,
But
Judge.
if we don't, we want something else.
Those of the county commission are not thoughts, correct? They're actions.
They are actions, Your Honor. I just want to.
So there's a dispute, an issue of fact as to which action was the true action,
Well,
correct?
yes, Judge.
Why shouldn't there be some evidence on that?
Here's why it's not relevant, Judge. On January 15th, 2001, the Air Force took its final action. They told us, you're not getting it for an airport. In fact, the economic development conveyance specifically excludes an airport use, and you're not getting the full property. At that point, on January 15th, 2001, this lease became void, the lease between the parties, because the lease, in several provisions, in the whereas clauses, in the conditions preceding, and throughout it, required two things. One, the conveyance of the full property, obviously including the runways where we were going to use it as an airport, and two, required the full use of the property for airport purposes. When that wasn't met, January 15th, 2001, we get the SROD, they get the SROD, the Air Force says you can't do it, then the lease is void of its own terms.
And that requires an interpretation that the lease requires the receipt by Dade County of all of the property.
And I'm happy with that, Judge. It's a pure question of law. Through that point, they've made no allegations that we acted in anything but good faith. So on January 15, 2001, either this lease continued in effect or didn't. We feel very strongly that it didn't. They don't have any allegations up to that point that we did anything wrong. So if you agree with us, if this panel agrees with us, and the lease was void, then what happened in March or December or in 2006 or 2008 is completely immaterial. And I could argue for the rest of the day as to why what we did was completely in good faith, but it's irrelevant.
Please don't count.
I won't, Judge. But it's irrelevant. I think it's irrelevant, Judge. So if there are no other questions, I'd just like to close by saying, Your Honor, this case has been through 6 years of litigation in federal court. There were opinions by both the lower and intermediate federal appellate court. Judge Hubbard had 3 years of handling this case, motions to dismiss, 2 motions to dismiss, and then a motion for summary
This goes
judgment.
all the way back to 1992.
The
facts of it.
The original rod,
Makes
yes.
the last one look like a toddler.
That's right, Judge. This one actually is almost an adult. Yes, Judge. So I think it's time for the case to be put to bed, and I think it's a pure question of contractual interpretation for this panel to engage in. Thank you.
Okay, thank you very much. Rebuttal, please.
Although this may make the last case look like a toddler, Judge Shepard, it's important to note that it was filed in the latter part of 2006, and it took the county almost 2 years to file its answer and affirmative defenses, and it took the county...
Seems to be a tradition now seems to be a tradition in the circuit courts that anytime there's civil litigation that you wait at least 4 to 8 years to file an answer.
No, Your Honor, but I will call a spade and tell you that it's not commonly known by many, perhaps, but that the county attorney's office is probably the strongest, largest law firm in South Florida.
And best paid.
Well, it has some of the best academic credentials of any attorneys, and if you are a plaintiff that hopes at any point to try to make some sort of settlement with the county, the 900-pound gorilla, it probably makes sense to grant them every continuance they ask for, which we did, and to otherwise comply with our ethical duties not to be vexatious, troublesome, I can't remember the rest of them, thrifty, nice, contumacious, etc., and to cooperate with them. So I wouldn't want, Your Honor, to think that we were dilatory in any way. And frankly, Judge Shepard, I don't know that I can say it better than you've already said it when you're asking about the questions that you have from counsel about, well, what are their duties and so forth. Actually, from 2001 to 2003, as the uncontroverted affidavit of Mr. Herrera states, they had secret meetings that Habdi asked to go to and was denied the right to go to. And the letters from the county attorney's office...
So what?
Well, Judge...
There's a deeply legal question.
Okay, well, let me give you a factual answer. For the 7 years previous to that, they went to all meetings, and there was always an agreement reached, including the application they did file
But their
in the
position is,
ACA.
their legal position is that as of 2001, when the Air Force acted as it did, this contract was over. They were just being a nice guy, if that is conceivable, which I doubt. They were just being a nice guy and giving you whatever you got, which was very
Perhaps
little,
that
but
argument-
they owed you nothing.
Your Honor, perhaps that argument might hold water, but for the fact that after the SICE was entered in 2000, and after the SROD was entered, it was that said they wanted them to abandon the 1994 ROD and to enter into the EDC. After that is when they took the vote and decided to join into that lawsuit. And at the exact same time had
Well,
these
how could
secret
they be
meetings.
heard? That it was not necessary for them to do that. Their position is that was a gratuity.
Your Honor, if it was a gratuity, it was one that HABD relied upon to its detriment, and therefore the county
How?
should be How?
How?
It's been, the
How
affidavit
did
shows...
you were pursuing your own case.
Correct.
They were just joining in the case. Their fact that they didn't join it
The trial court,
did
Your
not
Honor,
have any detrimental effect on the fact that you lost the case on the merits.
Your Honor, it had the ultimate detrimental effect because
Did the DC court, either one of them, say this is all over?
Yes.
Because the county has withdrawn.
Effectively, yes, Your Honor, because in the trial court and the appellate court, they specifically found that the cause of action was in favor of the county and not HABD. So when HABD unilaterally decided over, I'm sorry, I misspoke. When the county unilaterally decided to dismiss that lawsuit over HABD's objection, that was the death knell of both
So
the...
what were all these hundreds of pages of opinion if that was true?
Your Honor,
the county was not pursuing the only case, the only case which existed, which would have, if successful, have gotten the entire airport for use as an airport, correct?
Your Honor, I respectfully submit that when Your Honor has a chance to look at that, you will clearly see that it does say that that is the reason ultimately that they did not, or rather that they did not grant the relief requested, because it was a cause of action in favor of the county and not HABD. So
All right.
that was the ultimate death knell.
Your time is up.
Thank you so much.
Okay, thank you.